Good morning, everyone. I'm so happy that you're joining us for today's PA Academy. And this one is going to be one that you guys, the information in this particular webinar is something that you're going to be able to use every single day. So we're super excited. Before I start introducing our speaker, which I'm very excited, you can tell I'm very excited, right? I'm very excited to introduce. First, I want to ask everyone to please keep a lookout for the poll in the middle of the class. This is our regular housekeeping stuff. You know, I need you to answer that poll in order for us to give those CE credits. DFS requires it. And Jeff knew what I was going to ask next because he's been on these. Where are you? There you go. There's going to be a digital attendance verification form that's going to be posted at least 4 times in the chat. But we'll also email it to you at the end with a copy of the handouts and all that other kind of good stuff. We're asking you to please use the Q&A feature if you've got any questions, because it just makes it easier for us to get to the questions. Because as you can see, the chat is already very exciting. And if you'd like to speak live, don't forget to use the raise your hand feature and we will call on you live. Now, if you use the raise your hand feature, we call on you live, please pick up, because otherwise it's like, hello, are you there? Are you there? So good morning again to everyone. Hey, Rob. Hi, Roger. And welcome to PA Academy. So if everybody, now that you're answering the regular question, which is where are you from? Let's move to the next one. How long have you been a PA? We're really interested in knowing how long everyone in this group has been a PA. So do answer that question in the chat. 2 months. Craig, welcome to the industry. And then we're going to move right on. I'm going to go ahead and do the video, and then we'll start with introductions.
Welcome to PA Academy 2025.
Sorry, I just realized that you guys are not necessarily hearing it. Let's try that again.
Don't bury the lead. Strategic Communication for Better Claim Outcomes by Amy Boggs, Squire.
We're super excited to have Amy here. I don't know if all of you know Amy, but if you've been watching those testimonies up in Tallahassee, people that are fighting for advocates and advocacy in Florida, Amy is a star. I really hope you guys visit thefloridachannel.org and just type in Amy Boggs. And if not, what I'm going to do is I'm going to add some of those videos to the handout material link, because you got to see her in action. She's amazing. And with that having been said, welcome, Amy. And if you wouldn't mind taking a few moments just to introduce yourself to the group, I'd really appreciate it.
Sure. Hi, everyone. I'm Amy Boggs. I'm an attorney who has been practicing for 25 years. I've been working in first party for 20. So the first 5 years of my practice, I was on the defense side. Then I went to plaintiff's side, worked for the esteemed Chip Merlin, who is still a mentor and a good friend. And I've had my own practice for 15 years. So I will say that this isn't just something like that I kind of do. I live, eat, breathe this. I speak and write on this. I'm up in Tallahassee. I am policyholder advocate deep in my bones. So
that is the truth. Amy, could you tell me really quickly what this class, just a synopsis, a summary of what this class is?
Sure. So this class is really about communicating mainly in the written form, right? So we all have to do that. It's not just formal letters, it's emails. And what I see is that there is a lot of information. You all are very well steeped in your claim. You understand it. You understand the issues. Where there comes a problem is actually conveying that, and conveying that in a way that gets attention for your claim and action on the other side, which is really the goal here. So that's what this is about.
I think we have, for some reason, somebody is not muted. Okay, I just muted them. Sorry. So this is an important quote, right? What about just talking and talking and talking and talking and talking? You think somebody's paying attention to you and they're kind of like glazed over.
Well, I think that the thing is, even if they're paying attention, you have to focus the person. So when you're communicating, many of us have children. You know, when you say something to your child like, you need to take out the garbage, whatever. You think you're being clear, or employees. Nobody speaks hoping to be garbled, right? So the idea is that you think that you've communicated and the other side doesn't really know what you said. And if you were ever in therapy, they would say, mirror your partner and say what you think they said back to you, right? We don't have that luxury. That's not what we're doing here. And so if you want me to just launch in, basically, the whole idea is clarity. I'll tell my associates, I want you to be a bastion of clarity on this point. And so there can be no mistake. How do we do that? And by the way, the whole idea here is we want to focus the reader or the listener on the things that we think are important. If you think about the adjuster, and that's who you're writing this to, you are writing to someone who's got 1,000 files, their cell phone's blowing up, their whatever is happening. And so you want them, the name of the game is to get them in, to respond to you, to get focused on the things that are important in this case, and to get them to act. We all know, well, the squeaky wheel gets the oil, and there is a lot of truth to that, right? But it's not just a squeaking wheel that gets the oil. It's the squeaking wheel that says, hey, here's the oil can, please oil me, and I'm going to go, 10 miles for you if you do this. It is the person who gives the other side all the roadmap to resolve this. Now, we all know the other side doesn't always resolve, but at least you've taken control of the situation. So I think there's 3 important things to do, especially in letter writing and in handling your claims with the other side communicating. First, you want to take control of the timeline, right? Second, we're going to put the information in a very easy to understand format. Third, you've got to have a call to action. If I can tell you how many letters I've read from public adjusters, opposing counsels, my own associates, and there's no call to action at the end. There's no, hey, and we need this done now. And so we're asking this, what you've done is you just put a lot of information out there with no direction on what you want to happen next. So I'm going to take these in order. We're going to start with taking control of the timeline. Now, of course, there are 3 statutes, and this segment today is not to get into duties of responding, all of that. There are some statutes quoted in here. You should know them, look them up. This is really more about communication, but the statutes that I would say that are on point are 627-70132, 627-70131, and 627-4025. So when I say enforce statutorily imposed deadlines, if the carrier is supposed to respond to you in 7 days, that means on day 8, you've tickled a reminder following up, your response to me was due yesterday. Okay, so you've got to keep track of the timeline as well as they do. When you ask them to give you dates to get a reinspection done, you need to get that set within about a week. Continue to follow up until that's done. And if you send them an email and then 2 weeks later, you send them another email, you're starting all back at square one. You don't have an opportunity to say, hey, I sent you this 2 days ago, and you haven't responded. We need to get this set, etc. So you've got to be on top of the timeline. And that's typically a function of organization and being willing to follow up, because if you do, you will get some responses. All right. The second piece on doing this is you've got to hold. Yeah, these are not, sorry, regularly communicate. I've kind of went through these. So the timeline you deal with by knowing what the timeline is, first of all, keeping track of it yourself, and holding them responsible if they don't meet that. Let's go to the next slide. All right, this is really the meat of the presentation and the thing that I think that I can offer that maybe you haven't heard before in this way. Everyone will say, be clear in your communications, but today we're going to go through some actual examples of this is how you structure this so that it's not just clear, but it's methodical and organized. Don't bury the main point. And I use this with associates. I'll say, you know, don't bury the lead. What do you mean by that? What I mean is don't get into your story, your letter, your written communication to them, and kind of go chronologically. And down at the very end of this thing, you've got, and, you know, we're enclosing a proof of loss and you've got to pay in 30 days. That's the main reason you're sending this communication. So what happens is we are used to telling things in a chronological story, right? If we're talking to our friend, we're going to say, well, I did this, then this, then this, then this. And you won't believe, but then my car got hit. Well, you're telling a story, you're building up. The main point when you're talking to somebody that you need action from is my car got hit. So that's where you go first. It's like when you're watching a movie and they key in on a key, you know, or they zoom in on a keyhole. You're like, that's important. Then there's this kind of pause after this lady says red shoe. You're like, God, that's important too. And you go through this movie and you're grabbing these little context clues and you need resolution at the end. And we're all upset if the movie doesn't have resolution. Like, why did they make such a big deal about the key? That didn't even have anything to do with it, right? What we're doing is we're watching a story where we're getting information and we're trying to use our creativity to put it together. We want to do just the opposite in a letter writing. We want to say, I'm writing to address this thing, and then you address it. So they know as they're reading your thing, your whole point here is that your estimate is right and theirs is wrong. Or your whole point here is that they have misinterpreted the policy language with respect to who's responsible for drywall or whatever. We can go on to the next slide now. I'm not sure. Okay, yeah. So I did an example, and this is the meandering letter. So this has some information in it. It says, I represent the insured. We sent you an estimate. We haven't heard back from you. When we went to the property, you told us you'd get back to us soon. We haven't heard from you. Also, how can you say there's no wind damaged openings? There's a hurricane and water inside. You have all the photos. Your engineer didn't even go on the roof. Also, the guy who came out to the property, well, he's only been an adjuster for a year. He doesn't know what he's talking about. I think it's bad faith for you not to pay this claim. You have an obligation. It's been months. You haven't responded. And by the way, you mentioned you need some documents. We've given you everything a bunch of times. I'm not sure what else you need. We're not going to stand for more delays. You've asked for appraisal. We didn't get a response. Name your appraiser. Bottom line, there's coverage. Pay or we're going to sue you. This is just a cobbled together letter with a lot of really important points in it, right? But in reading this, if somebody sent you this, what would you feel like you're supposed to do? Would you feel like, gosh, now I've got to go see what documents they sent me? We have all the photos, I guess, of wind created openings. I guess I should go look through all the photos and find those wind created openings that he's kind of alluding to here in the letter. No, I don't think you're going to take the time to do this. So how would we handle this communication more clearly? Great, let's get to the next slide. Was really trying to say, we've given you our estimate. You need to either pay or outline your discrepancies, your dispute with that. Author was also trying to say, we disagree with your coverage position that there's no wind created opening and your engineering opinion is wrong. What you need to say is, and ours is right. Here's ours. Here are photographs 1, 2, 3, and 5 that show this thing. We turn your attention to these documents that we gave you that clearly establish that the association has responsibility for the air conditioning units or the window panes or whatever it is. He also wants to say we're concerned about your handling, both from a competency standpoint and from a timing aspect. We're saying you've got asked for documents that you already have. your delay in responding has consequences, and we intend to act if you don't do something ASAP. Those are the real things he's trying to say here, or she. Let's go to the next slide. So what he's done is just dropped hints. Instead of saying, we're concerned about the qualifications of your adjuster and that this is what's holding the claim up, we're saying your adjuster only has 1 year. You're leaving the reader to guess that what you're saying is the adjuster only has 1 year. He must not be experienced enough. He's not handling the claim right. You want to draw those conclusions for them, right? You want to say your adjuster is only 1 year in. We're concerned about those qualifications. In fact, we believe that's what's holding this up and is what is to blame for the disparity in our estimates. That's clear. You came away from that conversation or that reading of that letter understanding fully why the adjuster, the other adjuster's experience is even important right now. Go to the next slide. Okay, so after we're done with this, I would challenge you to go back to that first paragraph. And if we were in a writing workshop, I would have us all do that. And it is very effective. And after we get done with this, go back and say, how would I change this based on the new information that I know and the techniques that I learned today? All right, so your letter or your email, we talk about letters, and I'm dating myself. Most of us aren't writing full letters. I am in my practice, but a lot of it is just email communication. And just because it's email communication, it doesn't absolve it from needing clarity or some formality in your structure. The first thing is who. So it's going to be who, what, and why, or who. It's who and why first, and then what. So who. I always start my sentence. As you're aware, I represent Mr. and Mrs. Smith in regard to the above referenced claim. It's good. It gets them focused. They know you're talking about this claim, and they remember who you are, or you've reminded them who you are. Okay. Why? I'm writing in response to your letter dated blank where you requested the following records. So the first thing I say is who I am and why I'm writing. I'm telling them exactly. So now they're focused. I don't just say I'm writing in response to your last email. Maybe you could say that, but you want to say I'm writing in response to stating the facts and being clear in your communication. I guess, Nancy, are you reading the chats? Because those are popping up. I'm not sure if I'm supposed to be handling those. Sorry.
No, you're good. I'm reading
Okay.
them. If anything comes up, I'll let you know. No worries.
Okay, great. All right. This is my first FAPIA webinar, guys. So sorry.
You're doing great. Don't worry. You're doing great.
Yeah. All right. So I'm writing in response to your letter dated such and such. And we all know the date of the letter isn't really as important as what the text of it. I want to say where you requested these records. It's not just your letter dated April 12th. Now they've got to go look that up. I want to say your letter dated April 12th where you requested these documents, or your letter dated April 12th where you asked to do where you asked to do a reinspection. Okay. Again, we're focusing.
Can I ask you something, Amy?
Yeah.
Why is this so important? I'm thinking of this in terms of pre-litigation, right? And if you do have to go to a depot or, even God forbid, have to testify in court, how do these things come into play? Why is it so important?
Sure. So one, you look professional. And two, it's a great chronology and timeline. Right. So it's not just that the letter's dated April 12th, it's that this is the text of it. And frankly, for your own edification, for your own look back, you've got a nice, good record. I'm writing a response to your letter dated such where you've requested these 5 records. Now we're going to get into the body of the letter where I tell you what you're going to say next is, and we are here with providing. Doon, doon, doon. Now you've got a nice little Bible of what's gone on with the document request in this case. You've got it all nicely in there, and it's in a format that gives the cookies on the bottom shelf. Sometimes in litigation, and I'm certain that you all feel this way too, I feel like I have to work, not just do my side of the fence, but I also have to do work for the other side. I've got to make this really easy to get these documents or to understand our estimate. I've got to continue to follow up about an inspection that they want, et cetera, et cetera. And the truth be told, we shouldn't have to do that, right? If everybody operated in a purely professional context and were as efficient and on top of things as we all are, or as we all try to be, that would be great. But the reality is that that's not the world that we live in. And so instead of bemoaning, why do I have to do the other side stuff? This is ridiculous. Just get that noise out of your head and recognize that if I do that, I'm going to get this claim done. My client's going to be happy and I'll be moving on to another thing. It's really about strategy. You're trying to funnel these adjusters away from their 1,000 other files and into a little path that you've created for them in your claim. And when you do that, it's important. Someone just put that they like to include timelines of communication. Yep, that's helpful. But if you're just doing that to reiterate without a call to action and without a purpose. So at the beginning, we'll use that example. You say, I'm not getting, your issue is I'm not getting any response and I've done all of these attempts at communication. So you write a letter and you say, you know, I have contacted you on this day, this day, this day, this day, this day, and you put the whole chronology there. It's great. It's a nice, like I said, roadmap. At the very beginning of that, you've got to say why you're about to give them this information. I am concerned about your blatant violation of your obligations for timely communication under such and such. Specifically, here's the timeline of our communication. Okay, and then we're going to do a call to action, which is the close of the letter. But do you see how that is more effective than just putting the timeline down? In that guy's head, when he's reading that, he's like, well, I wasn't there that day. Well, I think I responded to that one. He's defending against this, right? In his mind as he's reading that, he's missing the point that you're making. The point you're making is get yourself back on track, bud. We need to get this done. And that's the whole point of outlining that. All right.
Let me interrupt real quick. Dylan's asking, do you find that it's better to respond by letter or to attach it to an email or just put it in an email? Does it really make any difference?
I think it makes a difference if it's a letter or an email. The one thing, I mean, from the perspective of litigation, the one thing that gets a little bit challenging, well, both have their challenges actually. The thing that gets challenging with attached letters is sometimes they're lost in translation. So we get a download of these emails and nobody's got the attachment that went with it. And that's frustrating. The other piece to that, or there were several emails sent on that day or several letters and you're trying to match up which letter was that with which email type of thing and what did they respond. The challenge with emails in litigation is that you have this whole tail. And the tail is helpful. It gets a little awkward. So I certainly, if you have an important thing that you're trying to say, I would try to just start it as a fresh email rather than tailing it on to a bunch of stuff where you guys have 5 pages of going back and forth about when you're going to inspect the property or something. So, but I think an email with an exclamation point, you can also put up at the top, please read, like in the ray line, time sensitive request. I find that if I put that in all caps, sometimes that gets more attention. All right, one more thing I'd like to say, yeah, I agree. The stuff that's coming from the carrier is laughable. It's just a bunch of cut and paste stuff, and they're just checking a box. They're not meaningfully communicating with you. And that may be something you want to say in your letter. Although I received your communication within 7 days, it wasn't a meaningful response to what I said. So please, the statute requires not just timely, but meaningful communication or something like that. One of the things I did want to say is we do a lot of phone calling. And when you call somebody, I have gotten in the habit, and again, I'm one person, right? But I have found it very effective. I assume the friendly, hi, Jim, it's Amy Boggs. I'm calling on the Smith case. And then I say, do you have a minute to talk? And I give them that courtesy to say, no, I'm running or I'm rushing or whatever. But really, it's more than a courtesy. It gets them focused.
Mhm.
So they're not just grabbing this phone while they're driving down the road. Do you have a minute to talk? Well, yeah. No, I'm about to say something important. I want to make sure you've got time and attention to listen to it. And so that's a technique when we're doing the verbal communications. Okay. Why are you writing and calling? Okay, so we said that we're, writing in response to your letter dated such and such where you requested the following letters. I'm writing to recap a conversation today about such and such. Here is how I understand our conversation. I'm calling as a follow-up to my email to you on blank date requesting such and such. I'm writing to address your denial letter and to correct some misperceptions you have about the claim. So when you get these handouts, the number 1 opening will attach to the number 2 Y, or the number 1 Y, and then it will attach to the number 1 body. So I say, I'm Amy Boggs. I'm writing about, I represent the insureds. I'm writing about this, and I'm clear. Now I've got them focused. Let's go to the next one.
Real quick, because the next one is our pop quiz.
Okay.
Why is it so important? And I know some of the folks that have been in this industry for a long time will know the answer to the question, but for our younger, newer public adjusters, why is it so important to memorialize your understanding of a conversation in writing?
Great question, Nancy. It is so that there is no discrepancy. We talked about the very beginning of this. The thing about communication is that it's often misunderstood, unfortunately, right? So we come away from this conversation and I'm going to do A, B, and C, and you're going to do X, Y, Z. I want to put that in writing. Not just some of this, people are always like, yeah, well, you got to document everything, CYA. Truthfully, there is some CYA, but more importantly, raise your head up to a bigger plane. The more important thing is to get the action that you want to happen. If they're supposed to do X, Y, and Z, you want that to happen. And so when you do that double check and say, I'm doing A, B, and C, you're doing X, Y, and Z, confirm that this is your understanding. That's great. Cookies on, my husband was a pastor for years. And so he likes dealing with juries and talking to them and putting it in. I'm much more intense, right? So he's the opening argument. I'm the closing. I want to hammer it all down. But he will say, put the cookies on the bottom shelf. Give this really easily in a gift wrapped bow to the other side. So it's not just covering your behind and documenting. It's really about promoting the action you want to take place. Yeah, paper the file, paper the file, paper the file, but do it in an intentional and effective way. That's carriers always say that they never received anything. So you've got your read receipts and you can send that. If you stay on that, the document piece, I'm going to address, because I know that one problem is where they ask for the same stuff over and over and over again, right? And so instead of just saying, we already gave it to you, or here it is again, I would say, stop, drop, and roll. take a minute, we're going to do this in the body of the letter piece, and say, request number 1 through 3 were provided to you by email such and such a date. Here's a copy. Requested, da, da, da. Now, and then when you get to the call to action, you're shutting down their excuses, right? They're running out of places to run to. I didn't get it. I didn't know you called. I didn't da 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 da. And you're enforcing the statutory timelines by being quick and responsive. And I'll tell you what, this is like, and we'll get to this more in the call of action. It is like a tennis match, right? So we hit the ball. We send them our claim. They go right back. We hit the ball back. To be effective, or the most effective, you want a net play. You want to be at the net and hitting it back so hard and so quickly. So if I get an email, and I was taught as an attorney, try to touch every paper once. Not everything's that way. But if I get an email that says, hey, we never got your documents, da, 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 and I'm like, I know I got that stuff. Half of my response to that email has already been created in my head. Half of it has already been created in my head. If I say, I'll flag that and do that later. When I go back to that email, I've got to reinvigorate, I've got to reread the email, whatever, instead of saying, hold on, let me just pull up my last 5 emails to him and bang this out. And when you are that responsive and that on them, they cry, at some point cry mercy and have to say, okay, we're done. They're lapping us. They're lapping us. So you want to stay at the net and keep hitting it back to them. Someone put serve and volley. Yeah, we want to serve. At some point, we're going to have match point, right? That they can't get to that and the dam breaks or whatever. But that's really going into litigation. Your goal is to stay out of litigation. Your goal is to get out of the volley, excuse me, and to get the match over with, right? After one game, or one set. I don't play tennis. I mean, for fun, but so I don't know all the terminology. But I do know that the quicker you're responding, if they're saying, well, we never got our stuff back, you can write back, thank you for responding on the 7th day per the statute, but here's where you did get the stuff. And they're like, oh, Jesus, I sent that email thinking I'd have a minute to breathe. We deal with this with clients sometimes, right? When someone's on us, we're like, I wrote her a long email yesterday asking for a bunch of stuff. I thought I had a minute to breathe until she got that back to me. And dang, the next morning it was all there, So that's what you want to be in this. So let's do our quiz. The next half of this after the quiz is going to be longer. So.
All right, I'm launching the pop quiz, which, as you all know, is a requirement for DFS. You don't have to get the answer correct, but you have to answer. So are you all seeing the quiz right now? There we go. Somebody just answered, so somebody's seeing it. If any of you are having any technical issues where you cannot see the poll, please write to me at paacademy@fapia.net. That's paacademy@fapia.net. Just let us know that you are having a technical issue, and we will be able to keep that in the record. So the question is, we're all about strategic communication today, but let's be honest. What's your go-to move when an insurance company rep starts burying the lead? So far, the #1 answer is casually drop per Florida statutes, like a mic, right? These are some good ones. I like it. So I have, let's see, 100% have answered. That is a new record in the history of PA Academy. That's awesome. So ending the poll, sharing the results so you all can see how everybody answered. And we're moving on. So now you got to turn on your mic again.
Sorry, that's great. That's great. Okay.
Moving to the next one.
Okay. This is the meat of it. You told them who you are, reminded them who you are. You told them why you're writing. Now, the what. What are you trying to tell them? What are you doing? You're enclosing records, you're whatever. So this first thing, when you go back, my first sample of the why was, I'm writing in response to your letter dated such and such, wherein you requested the following letters. And then your next sentence is going to say, I am pleased to close herewith the following records. And then put your specific items and then match those to the requests. Where you don't have records, who's dealt with this? Where we've given them everything. We've given them everything. And then they're like, well, there are no home inspection reports from when the home was purchased. So we still don't have the home inspection report. And you're like, there isn't one. I told you we gave you everything we have. Go more than that. If there's a request for all home inspections, you can say, here's one that was done, you know, a 4-point inspection. Note that the owner never had the property inspected when they were purchased. Identify the absence of records that should easily be available, that conspicuous, or we don't have the condominium association's records because they were destroyed in a fire in 2022. So be complete. I kind of call it the rule of completeness, where you read what you wrote and say, if I read that, I would have no questions about what's going on here. I would know exactly what they gave me in response to my first request. I would know why they only have 1 year's worth of records on that second request. I would know why they have a bunch of stuff on the third, etc. Right? So you're trying to create not just a record, but a roadmap so that they can easily digest this. I go a step further, especially where there's a lot. Think about when you're providing documents and records to the carrier, they might say, I want 5 years worth of records on this house or whatever. Just a tip, talk to your homeowner, talk to your condo association. Find out, did you do some major capital improvements? Like, you want to substantiate, they're asking because they want to show that the building or the home was not in good condition before the loss, right? We want to show them that it was. It's hard. It's like pulling teeth sometimes to get records from clients. But if you explain the need for that, listen, Mr. Smith, you maintain your home beautifully. I want to show that to them. So yeah, when you have the guy cut your lawn, all whatever, right? So yeah, you had this restuccoed. Associations are a little easier, but you know, sometimes they're difficult because they change. They're not the best record keepers either, let's be honest. But I want to go back to the last major capital improvement, right? So they're asking for 5 years. I want to say, but have you done anything in the last 10, 15 years of consequence? And you might find out, yeah, we replaced the entire kitchen 6 years ago. And so, yeah, we could do a whole other thing on condominium association stuff. But so I want to include that, and I want to highlight that for them. Although not asked for, I've included the records related to the entire kitchen renovation that was done 6 years ago, even though their request was only 5. I also, if the home or property or condominium association is in great shape, or if repairs are underway, again, I try to put the cookies on the bottom shelf. Do a little spreadsheet. Here's the work that's been done so far. Here are the invoices that are tied to this spreadsheet. Make it very simple. It's not only helpful for you, so you don't have to go back in and say, no, what was going on with this again? It's helpful to get the claim paid. It's helpful once it comes to litigation, and it's helpful with the client. There's been a rash of cases recently, unfortunately, where policyholders signed a proof of loss based on an estimate, and work had been done, right? Most of us deal with claims where some work has been done. The work that had been done, minuscule, maybe it was remediation or, you know, roof was put on, whatever it was. the actual cost of that differed from the estimate, and it was lower. And don't you know that the carrier got summary judgment and the entire case thrown out of court because of a material misrepresentation? They said, listen, at the time that the policyholder signed this estimate saying, or signed the proof of loss saying that the roof was $100,000, they knew they had only paid 70. So I know policyholders don't know that. That's the fault of the people who are dealing with their estimates and their numbers. So it sent a shiver down my spine. I will not just submit an estimate and then the receipts on the side. I want to change my estimate out, but I can at least do a spreadsheet. So we're on the same page. It's not just giving it to them easily, but you actually need to track that yourself so that you don't have the client signing something that gets their claim completely denied. And it's denied. Any money that's already been paid is clawed back as well. It's a death sentence. So you want to be very, very, very clear. And when I'm producing documents and records to the other side, I want to be very clear. I don't know if anybody knows how to Bates number. That's something we do in litigation. I think it would be a great thing for public adjusters to do as well. It's a function on Adobe and it just numbers things. And so if you're, ABC public adjusting, you would do ABC insured, and then it numbers every document, not the document, the pages. And so you put these things into a straight run PDF and it's all produced. I also produce it in subfolders. Here's all the repair things. Here's all of these things. Here's all the estimates. Here's all of the reports. So again, it's really easy for them to have, but then I've got a record. All of those things are numbered and we know exactly what pages were provided. It's very, very helpful. And then, by the way, if you're doing your letter here responding, you can refer to those Bates numbers. Say we provided Bates numbers 1 through 812 to you on such and such a date. All right, let's go. Okay, so my first example here is where we are giving them documents. The second one is that we're telling them, hey, we've already given you this. And that's important to say with clarity. And I think I've kind of beat that horse to death, but you want to say, listen, we provided this record. Okay, let's go on to the next one. We provided this record and this is the date that we did, and we're providing it again here. All right. My second example was, hi, I'm writing to you as a follow-up to our conversation of such and such. This is what I understand. And we did talk about this one kind of before, but you want to outline exactly what's going to happen and the dates. So one thing I do, especially if I have a conversation, they're like, well, hey, we want to re-inspect. I'll say, listen, we want to move the claim along. Can you get the inspection done like in the next 14 days? And I get them locked into that. And it's not legally enforceable, but it's a marker. It's now they have some kind of deadline. Like I'll talk to the other side. They're like, yeah, we want to re-inspect. We want to do this and all, and then we want to mediate. I say, well, let's set mediation 60 days out and you can accomplish these things in that next time period. It's getting control. So get them not to agree on a date, but a reasonable time frame, and then put that in this letter. We agreed that you were going to re-inspect. You're going to do it by then. And you also said you were going to bring these people to the inspection, because I know that's sometimes an issue. They show up with not enough or whatever, too many. All right. So the question about whether they should recite statutes on letters to the insurance carrier, some attorneys might say, well, that's crossing a bit of a line. But these are statutes that govern timeframes that you work in. So I think that that's completely okay. I wouldn't interpret that and say, well, hey, if you don't do this, this is the consequence and all of this kind of stuff. I would say just a reminder of the timeframes in statutes, this, and this, and we're beyond that. So interpretation is the issue. But again, you are being governed by those statutes. You are having to operate in them all the time. So you certainly should have an awareness and can remind the other side. All right, the third example was that I was saying, hey, listen, I'm writing to you because I didn't get a response to the email that I sent. All right, you're going to say, not just that I didn't get a response from you. I'm writing as a follow-up to my email from such and such a date. I'm going to say the email was sent 8 days ago. Don't do it on the 7th day, right? They've got 7 days. Give them 7. Do it on the 8th. This email was sent to you 8 days ago, and I haven't received a reply. And as you're aware, under statute 627-70131, you 7 calendar days to review. And by the way, clarify on these, take note, first of all, that some of these statutes, they're very sloppily written. Unfortunately, I'm not surprised, but they are. It will say calendar days or just days. So it might say business days, calendar days, or just days. Sorry, those are the 3. So make sure what you're dealing with. If it's 10 business days, then quote that properly, right? All right, we can go to the next. All right, the body of the letter where you said that I want to, remember you said I'm writing because I represent Mr. and Mrs. Smith, and I'm writing because you have some misperceptions about the claim. I'm writing to correct some misperceptions that you have about the claim. And then you want to go into them. And I would say, I want to address specifically your contention that there is no wind created openings that led to water damage. Say it. That's inaccurate. Don't say you're lying. That's, your engineer's full of garbage. That's inaccurate. I've enclosed the following materials which demonstrate that the water damage was in fact a result of wind created openings. These are literally samples that you can use, modify, whatever. This isn't just, hey, be clear in your letters. I wanted today's webinar to be concrete examples where you can see there's no question what's going on here. I told them that their position was wrong, and that I'm going to demonstrate to them why it is wrong. And then you line it up. Don't just say, here's a bunch of photos, etc. So you're going to say, here's a photograph of these units or property which demonstrate X, Y, Z. Here's a report from this, engineer windy day. I thought that was cute. Finding that, and then quote the report, finding that there in fact were 10 wind created openings, moisture mapping, whatever you've got, outline it right there. If you have nothing and you just want to say, hey, there clearly was water inside, it was a category 5 storm, you can say the insured should not be required to go to the expense of hiring an engineer to have you pay what's obviously a claim. But put it there so you can see from these photos that there was interior water damage. It could only get in from an opening during this storm. Whatever your point that demonstrates your coverage position, put it there concisely. I like bullet points. I like numbered lists, etc. All right, next one. All right. Call to action, and this is the thing most people miss. Even if you're very, very clear in your letter, you've got to tell them that you want them to do something, and you want to give them a time frame to do it in. So what do you want them to do? I'm asking that you reconsider your coverage position timely within the statutory time period allowed. I'm asking that you re-inspect the property so I can show you the damage, and I'd like to get this accomplished in the next 2 weeks. All right. What are you going to do if they don't do that? Right? So saying, I want you to come back out. I want you to pay the claim fully. I want you to change your coverage position. Those are the action items. That's what I want them to do. And what are you going to do if they don't? And you want to tell them that you want them to do it within 2 weeks because that's a reasonable time frame, or within 7 days because that's what the statute requires, or within 5 days because we're coming up on the 60-day time frame for paying the loss within 627-70131, or whatever it is, right? You want to tell them the time that you want them to do it in and what you want them to do. Now, what are you going to do if they don't? Well, that is, yeah, is it ever a good idea to threaten a lawsuit? So let's get into that. You can go into all right, so the opt-out basically says this. The opt-out says, I have provided you with our estimate. You've done your letter. You said it's been given to you multiple times and you've re-inspected the property. At this point, we're asking for payment in full or a concise statement about what you're not paying and why. That's your call to action. That's what I want them to do. We want that within the next 7 calendar days per statute. If we don't hear back from you, we're going to assume that you agree with our estimate. Now, can you hold them to that? No. But we're going to assume that you have no dispute with the things in our estimate. You can't hold them to waiving their right to challenge your thing, but I can tell you what, that will get a response. And I know from doing bad faith discovery that on the back end, when you look at this, they calendar these little arbitrary deadlines that I was just kind of giving them. Like, hey, if I don't hear back from you on our demand, I'm going to file suit on this day or what have you. So those things do mean. Notice an opt-out is different than an opt-in. An opt-in says, I want you to do this thing. Please tell us that you're going to go ahead and accept this within 7 or 8 days or whatever it is. That requires them to tell you they have to do something. Opt-out says, I'm taking control. I'm going to do this thing unless I hear from you. Okay? It's a big difference. You can think about it in terms of like when citizens did their takeout policies. At the outset, you had to write in and agree to go with someone else. They realized that nobody was doing that. No one wanted to pick up their pen and do that and deal with it. So then it became an opt-out. Hey, you're going to get switched to this other person unless you object. And a lot of people got switched because they didn't object. So the opt-out says, we're going to inspect the property on such and such a day. If you are not there, or we agreed that you were going to inspect the property in 14 days. We are beyond the 14th day. If you haven't inspected the property in the next 7 days, we're going to assume that you no longer need the inspection. We've given you all of our documents. If we don't hear from you in the next 3 days, we're going to assume that you need nothing further to reach a coverage determination here. All right. 3 strikes quickly is this, where, oh, I didn't realize I had all these examples right now. Sorry. Okay. You can just give them that to take home. 3 strikes is this, is we've attempted to schedule this reinspection. So I'm trying to do the 14-day thing. You're saying to them, hey, schedule this inspection. 2 days later, I'm following up on my request that you schedule the inspection. 2 days later, I'm following up on the request that you schedule the inspection. If I haven't heard back from you by the close of business 3 days from now, I'm going to assume you no longer need this EUO or you no longer need this thing. But you can only do that if you're following up quickly and regularly. So I call it the 3 strikes. If you do an email and then 2 weeks later you do another one, and then 2 weeks later you do another one. So your first is, I need you to do this. 2 days later, following up, need to get this set. Third one is, this is my 3rd follow-up on this. I'm assuming you don't need this. Or if I don't hear back from you to schedule this in 2 days, I'm going to assume you don't need it. And that's a fair assumption. You don't have to continue to chase them. You can put these deadlines in through opt-out and 3 strikes. Let's go to the next piece. Yeah, taking the high road and making the carrier rise to the occasion. This is something, like I said, I've been litigating for 25 years, and I'm sure a lot of you have been doing this for a long time too. If we're not growing, we're dying. If you're not looking at the way you're doing things and adjusting to improve and be better, you're just not probably reaching the potential of professionalism that you want to have. So one of the things that I have come to as I've matured in my practice is that if you expect the other side to do something, to act appropriately, and you tell them that, they will sometimes, not always, rise to the occasion. But at least you have set the expectation about how we're going to communicate here. All right. So let's go to the next piece to this, because we're running out of time. All right. Yeah. Don't ever call, you're a liar. You're lying about that. Instead, you want to say, you apparently have some misperceptions. Your statements are inconsistent with the facts of this. You can call them a liar without saying the word liar. And again, as you're doing that, by the way, remember, what conduct am I trying to promote from the other side? Am I trying to get this guy bulled up and angry and pissed off, and it'll be a cold day in hell before I ever pay that guy's client's claim? Or do I want them to say, when they think of working with me, do I want them to say, he was really good to work with, professional, on top of stuff. He'll keep you on your toes, but I found him to be honest and on top of things. That claim's going to get paid. I want to get that claim paid for him. I don't want to get the claim paid for the guy that's calling a liar. And remember, your job isn't to best these people, outsmart them, call them out. All of that feels really good. And I have done my share of it. Trust me, folks. But I have found that if I really want to move the other side, if I tell another lawyer, I'm going to kick your butt, we'll see you in court, buddy. See ya. When I do that, any lawyer worth their salt's like, okay, yeah, I'll see you, bub. Nobody goes, oh gosh, I'm afraid, right? Think of yourself when the other side comes at you. You don't cower. You say, well, I'm going to fight this one even harder. So we don't want to do that. All right, let's go to the next thing. These are samples, again, examples that you can take home. So you want to remind them of their obligations and assume that they want to adjust the claim fairly and properly. I want to remind you that you had 7 business days to respond to me and you failed to do that. I know that you want to comply with the statutory timeframes as much as I do. So let's get back on track. Something like that. Again, what's wrong with saying that? Nothing. All right. So I also, instead of saying they're a liar, I think it's important that we all work with a complete set of accurate facts in handling this claim. To that end, I'd like to correct some misperceptions surrounding the claim as follows, and then lay them out. All right. He's calling you a liar saying we didn't attend the inspection. You can say, you stated that we failed to attend the inspection on this date. For clarification, that inspection was actually scheduled to take place on this date, and then you unilaterally changed it to another, and then it got set and you didn't provide notice. It's unfortunate that happened. Let's get the reinspection set. That's the way to call them out for lying. And it's not just keeping a record, it's saying, actually, let me tell you how it went down. A C is a good example. You stated in your letter that the insured didn't even know when the loss occurred. Actually, what the insured stated was this, and it was you who questioned him about the potential earlier date of loss. The insured was clear about the facts surrounding his loss. So you told him up front that this is the problem in his perception. You told him what happened, and then you corrected the misperception, right? I didn't have to say, you put all those thoughts, you got him confused, you're a jerk, you're bullying him. All of that stuff is not helpful. All right, accountability examples. So this is, again, assuming that they want to be professional. And if you assume that, it's going to be good. All right, this is the third time you've requested the same records and we provided them. I know that we're both working diligently for our clients, so let's get on the same page about what you have and what you still need. Today we've provided this stuff to you. You can also say, I've worked in the industry for blank years. I can appreciate how busy you are, right? However, I can't understand your utter failure in meeting the commitment to timely justice laws. I'm trying to work with you, and I've been responsive and communicative. Please note that your reference to our estimate being inflated is inaccurate and frankly counterproductive to us resolving the claim for our mutual clients, right? So you want to remind him he's working for a client too. And when he says, your estimate's way blown out, instead of saying, screw you, yours is too low, or yeah, where's it wrong, bub? You want to say, this is counterproductive. When you use words like inflated, it conjures up fraud and negativity, and frankly doesn't help us work together, which I know we both want to do. And then I did this recently. I had a letter that I had to send to my clients from an opposing counsel who is really, really awful. And so I snapped, jerked a knot in her tail and said, finally, I'd ask that you consider the tone of your future communications. In that case, we were trying to settle it. I said, frankly, your communication almost broke up the entire, settlement. So my client's eager to get the claim resolved. Harsh tone of your communication is making it difficult. Indeed, it's having a negative effect on our entire ability to do anything here. And when you call the spade a spade, it is helpful, right? You say, hey, your tone is now a problem. And here's what I mean by that. And I'm just going to reiterate, not blanket that we want to work with you, but that I know you want to work with me too. Let's go on to the next one. Assume the close and cooperation. I always tell them at the end, I look forward to continue, even if we're not working well together. I tell them I look forward to continuing to work with them to resolve the matter amicably for our respective clients. Again, remind them that you're working for a client and so are they, and your obligations are to try to work together. Next. Okay, these last slides are really for your reference. They're some of the statutes. So it's not just a matter of best practice, it's a regulatory issue as well. You can go on to the next. These are tips that you can keep. You can identify common barriers, develop listening skills. These are more big picture. My goal today, and just for your reference, my goal today was to have not big picture, very specific in the things that you deal with on a day-to-day basis. It's fine to say, identify common barriers. But what really you need to do is get in the weeds with it. Here is the barrier. The barrier is that I've given them documents and they're not responding. The barrier is he's being a jerk. The barrier is he's not responding. So how do I deal with that once I've identified the barrier? That's what this is really is supposed to be. And if you take this back again and you go through the thread of the opening, the why, the what, and the call to action, those things should match up. The number one thing, you could take the number one on all of those and it will create a full letter-ish for you. Number two is examples how you deal with that. So go ahead. Yeah, kind of the wrap up is focus, get to the point. Also avoiding unnecessary back and forth. If you're going back and forth on these emails with them, you probably in your gamesmanship, and believe me, I can get into it too, but at some point I've got to stop and say, at this point we've discussed this topic enough. Here's what I'd like to happen, and I expect that you would like that as well. That's the sum up. So how did I do? Am I right at the
I
time?
love it. This is the last slide. You're amazing. We really appreciate you, Amy. This is kind of a wrap up. For those of you who have any questions, please be sure to put them in the Q&A. Brian's got a question, and I'm going to get to him in just 1 second. But I did want to remind everyone. Go ahead, Amy. What were you going to say?
Just say, listen, use me as a resource. You're going to have my information at the end of this, and feel free to call me. You know, I have public adjusters, even ones that I don't work with, that will call and say, hey, I'm in this situation. I don't even know how to deal with it. And I'm happy to be a resource. I have a practice in St. Petersburg. My husband and I practice together. And I've got 2 associates. They're great. They're all handpicked. We're a small but powerful firm, and we really like to do things with excellence. So I've got people who can help you.
We've got a lot of folks giving you thanks in the
I see that.
chat.
That's so
It's very
nice. Thank
cool.
you.
So don't forget, you guys, to sign up for well, we don't have the registration link live, but we should have it live by Monday. We're just waiting for DFS to approve the mandatory 4-hour law and ethics. So we will send an email out to let you guys know about that. And obviously the October conference, we hope to see everyone there. We've already got a bunch of people signed up. We've got all kinds of exhibitors. I think we only have like 10 exhibitor booths left out of 50. So that's pretty amazing. So hope to see you there. Visit FAPIA.net, and there's a link for FAPIA Live 2025. And we do have a couple of questions. Let's see. Brian is asking, this is not quite of the part of the presentation, but in his communications with the carrier, what can we cite that confirms that the policyholder is obligated to demonstrate the loss during the policy period, and it's the carrier's responsibility to prove an exclusion? In other words, not just provide their opinion that the loss is excluded. Is there a specific case or statute that can be referred to?
That's a good question. And the answer to that is I would not cite case law to them. I don't think that that's appropriate. I think you can say it is well settled in Florida. But when you're talking about whose job it is to prove something up, what you're really referring to here is who has the burden. When you talk about burdens, we're talking about burdens of proof. And now we're talking about trial. So you can see this path that we're going down here, right, is a legal path. So when I talk to clients about this, I try to explain that it's not just a legal concept, because you're right. This is the day-to-day on the street. Whose job is it to show that this is covered or not? So I think if I were you, what I would say, the term all risk policy carries with it that entire basket of law. So as you're aware, this is an all risk policy. As such, the loss is covered unless it's excluded. And the job is on the carrier to demonstrate dispositively that the entire damage was caused by an excluded event. And I think you can say that. If they come back and say, it's not our job to do that, or we did that with our opinion, I think the question you're really trying to ask me here is, if they have an unsupported position, how do you deal with that? And explain to them that they need to have that supported. And I think, unfortunately, you can't deal with that. In fact, we can't even deal with that until it comes time to require experts, right? So the point is, creatively, you might say your opinion is unsupported by either facts related to the case or from an expert opinion. Sometimes, who is it? Who am I talking to? Juan?
I can't remember who it was. It was Brian.
Okay. I'm sorry. Okay. Sometimes, Brian, you're driving up this tree, or you're driving at this point, and you need to back up and go kind of bigger picture, even if it's not your job to demonstrate that there were wind created openings or whatever the situation is. or it's not your job to demonstrate that this is not wear and tear or what have you.
And is it a
It
good
doesn't,
idea? I'm sorry, go ahead.
it doesn't hurt for you to say, and your opinion is wrong, opposing OA, because look, if this had been getting wet, if this was wear and tear, it wouldn't have whatever. And you can give some facts that you think support your position. Even if it's not our job to prove that, it's okay to put some information out there, your best arguments about it, and make them come forward with something more than an opinion.
And you can also send them a coverage determination letter and specifically ask, what are you basing this coverage determination on? Is it policy language? Is it the inspection? What are you doing? Where are you coming from, right?
Well, unfortunately, I think the coverage determination letters often say we're denying your claim, and then they cut and paste a bunch of policy language in there, and they
Yeah.
don't tie the facts of the case to that cut and paste. So where does that leave you? You're kind of screwed then, right? So then you've got to say, okay, go back and say, please tell me first of all, out of these 10 cut and paste things, which ones specifically you think are apparent here, and then give me the facts related to that. I want to work through this with you.
You know, I had a case one time back in the day where they sent me one of those cut and paste letters that contained policy language. And I had read the policies, and when they sent me this language, I was like, I don't remember reading that. And I went back to the policy and it wasn't in the policy.
Oh yeah, sister, that's a really good point. Check your policy. If you are not checking your policy and making sure your forms and endorsements, I've had that happen before too, in both ways. I've had it where I was quoting stuff that they didn't have in the policy, and where they were quoting stuff, I was quoting stuff that was actually in the policy, not in the certified copy they sent me, but that was on the endorsement page. And I've had it the opposite way, where they were quoting stuff and stuck the endorsement that shouldn't have been included into the certified policy. So yeah, check that policy. And also, by the way, whoever else is on here still, these policy
people still.
Okay, good. These policy forms and endorsements change often. If you hear me in Tallahassee, what I say about this, how I boil it down for people, is the insurance policy is a contract that's negotiated for the policyholders by one guy. It is our OIR, right? Our insurance commissioner. He's our chief negotiator for the policyholder. So if you think about that, because we don't have any form, how many people have clients that say, if I would have only known there was this in the policy, or if I would have only known that, I'll say you would have never known that, right? The person who approved that going into your contract for you is your esteemed insurance commissioner. And we, know where his pockets are lined. I would just say, I don't mean to say it like that. We know where I think his loyalty lies is a better way to say it. So as you're looking at these policies, because these changes happen so frequently, the carriers often don't whoever said I can say it like that, thank you. These policies often are not changed fully, right? So there's inconsistency where it's referring to a wrong page or whatever. Check that. The other thing to check, and this is, I've had a lot of adjusters miss this trick, is that when you get a client's policy, it's got a water limitation in it or something, one of the newfangled roof endorsements or whatever, get the year before's policy. So the prior year policy, if there's a change between year 1 and year 2 that decreases coverage, there has to be separate notice provided for that. So the general rule is that once you receive your policy, by the way, you're charged with knowledge of everything that's in that policy, unfortunately. There's an exception where there's been a change in the policy and separate specific notice has to be required. And so you can go back to the prior year policy language, but you can only do that for 1 year, meaning after it renews again, you're out.
Right.
Right. So I've successfully, for a condo association, got the old collapse language put into a policy where they didn't provide notice of that. And so you do, when the sinkhole statutes were changing, we had a lot of that stuff too, that they were shoving stuff in that wasn't that notice wasn't provided. So check that out. Don't take the policy at face value.
I got a couple more questions here.
Okay.
Adria is asking, does this apply for all policies? I suppose she's talking about that last thing that you just mentioned about going back.
Yes, it does. Surplus lines will not be required to provide as much notice, but that's a good question. I would have to look into that about whether they have some separate obligations about notifying on renewal about changes, but they should be about the same. If you're asking about the all risk thing and whether that applies to all policies and the burden, the answer to that is no. Your policy, your typical homeowners policy or condo association policy is an all risk policy. Everything's covered unless it's excluded. However, note, by the way, buried within your policy there, your contents coverage is a named peril coverage. Okay, so that means you, on the dwelling, you don't have to prove that it was wind damage. The carrier has to prove that it was damaged by something other than wind. On your contents, you have to actually prove up the peril that damaged them. So just an FYI. Right, so that's an all risk policy. With respect to a wind only policy or a named peril policy, those are not all risk. And the burden there falls to you to prove that it was flood damaged or that the peril that this is insuring against occurred during the policy period causing damage. So wind and believe it or not, well, you guys probably do believe it because you work in this industry, that gray area becomes important. There are cases that I would assess under a wind only policy as not as great, really, this gray area, as cases that are under an all risk with the same facts. And I have had that where we're like, one of our challenges here is that we have to prove that all of this was wind damage, not construction defect and the other things that they're alleging. So if a carrier is astute, they'll say, God, this is a named peril policy. Not only do we say it wasn't caused by wind, but we point to a bunch of other things that the insured bears the burden of disproving, essentially. Just FYI.
Yeah, that's a good one. Dylan is asking, what more can be done if a carrier is not replying to anything? Calls, emails, and universal is the biggest issue. Shouldn't they report that to DFS?
Yeah, I think you should report that to DFS. Absolutely report that to DFS. You can report that to supervisor. I would report it to, I would even send that to OIR, frankly, and get an attorney. Yeah. So I'm going to tell you, when cases come to me and they've been beat to death and there's a lack of communication, let's face it, in the current legislative climate, the carriers have been emboldened to do this. So the legislators were so proud of themselves for making stronger timelines, and you can't have 5 adjusters and all this stuff. They buried the lead because they did these little sexy things and then eradicated any right to enforce it, essentially, right? So it's kind of like without being able to hire an attorney, without having to incur costs and stuff like that, they greatly diminished the insured's ability to enforce these new timeframes and stuff. So you bring up a good question. What do you do? When I get a case in, especially if it comes from a PA where it's already put together, I drop a notice of intent to initiate litigation as soon as possible. Because that gets us now really in control of the timeline, right? Now they are on a clock ticker and the lawsuits coming down the pike. And so maybe if you literally cannot get, somebody asked a question earlier, should you threaten to file a lawsuit? I don't know that I would threaten to file a lawsuit. I don't think it's bad to say, you have given us no choice but to turn this over to counsel. Your lack of responsiveness and failure to comply with your statutory mandated timelines have left the insured no choice but to seek counsel. You know, so yeah, so at least saying that you would seek counsel. But I one quick word about litigation, that you know, you guys are in your own world, we're in our world, and our worlds, of course, overlap a lot. Litigation used to be the place that cases went to die, a black hole that nobody ever heard anything from again. And it was very frustrating to public adjusters who handed their babies, their clients, their cases they'd worked on over to us, right? So there's a new sheriff in town in Florida. We have to get our cases tried within a year to 18 months, which sounds like a long time. But I'm going to tell you, I've got cases from Ian that are coming in, and the clients are, you know, the PA and the client have been trying to get this done themselves. The people who brought it early are done. And when you get the carrier in that defensive position, because there's a day of reckoning coming, we can argue back and forth all day long about the value of this estimate. When I get it in litigation, I've got a backstop. The day of reckoning's coming. Someone's going to decide this, bub, and it's not going to be you and me. It's going to be these. And here's what I think these are going to do. And that threat, on top of a civil remedy notice that I do in litigation or at the beginning of litigation, plus the NOI says, we're here, we mean business, we'll talk to you, but we're marching towards a day of reckoning.
I love that. That visual is so good. All
Well,
right.
I'm so excited about it because, again, I'll always, in doing my cases, the minute they answered and I could do a notice for trial, I did. So they did an answer and I would get them. And so even with that aggressive approach, I still couldn't get my stuff pushed through. And I have clients, I bleed and love my clients. They're living in a FEMA trailer. They're, you know, et cetera. So that timeline isn't, but I feel like we have a lot more power now to move things along.
Well, we've got 3 more questions.
Okay, sorry.
It's okay. No worries. You're doing great. And we still have 52 people on the call, so we're doing great.
Oh, good.
Cindy's asked, do you have any guidance on verbiage for getting a carrier to agree to pay overhead and profit?
I think you just need to say that this is industry standard, perfectly acceptable. And, you know, if it's been incurred, certainly. If the client is acting as their own GC, then or that's into, you're talking about just on the estimate, I guess, where repairs haven't been done. Yeah, then I would just say this is the industry standard, certainly due and owing. And it would be a shame to have this small component to the loss be the thing that prohibits us from resolving this claim. Put it in context with them.
That's a good idea. I like that.
Yeah.
Ruben is asking, what are your thoughts on the Citizens Department of Administrative Hearing?
Oh, Ruben. If I could curse very loudly, I would. It's awful. My thoughts on it are that it's awful. There, so Chip did a blog about this recently where he brought the stats forward, right? Somebody else, another attorney, who he properly attributed to, brought forward the stats. No policyholders have won those. Not only are they not winning those, but the DOA judges are awarding fees and so on and so forth. So I think it's awful. I think we have to figure out how to, by Cindy, we have to figure out how to maneuver that. When that legislation was being considered, again, I'm now going to use our theme, bury the lead. what happened in December of 2022 was that there were so many changes, the biggest of which was essentially killing bad faith and attorney's fees, right? So slipped beneath this 80-page bill, buried in that, is this whole thing about citizens. And there was going to be a grandfathering, a slow rollout of these things. So we're like firemen showing up to the fire, and this place is ablaze and people are dying inside, and the neighbor's property is going to be affected at some point, but we got to go into this other thing. So all that stuff got shoved in, and it's concerning. The one thing I will say is that there are some clients. Oh, good point. Somebody says, oh, Roger, hi, Roger, that there's a DOA. Yeah, no, it's not valid if it's not listed in the deck page. He's saying that there was a request for DOA, but it wasn't in the policy, or it was in the policy, but not on the deck page, kind of what we just talked about. So make sure, again, you're looking at that. So there is one of my colleagues who I love and usually present with at Windstorm is doing a constitutional challenge to this. And
Oh.
when the legislation went through, when bad legislation is coming down the pike, Nancy knows this, you have some options. If you can kill it, that's the best. If you can't kill it and you wind up trying to tweak it, so this is going to happen, let's see what we can get, that's another option. If it's so bad and poorly written, you have the option of just saying, we're not even going to engage about it, let it pass as written, and we can challenge it later because it's so poorly. Let's not fix it for them.
Right.
And make it legal.
Make it easy, right.
Right, or fix it and make it constitutional. You know? So
one more question from Wendy, which kind of goes along the lines of what Roger was just talking about right now. She's saying, why is it okay that you have to sign and bind a policy before you're even allowed to look at it? Is that a legal contract? If you're having to sign something before reading it? Well, it's a legal contract for sure.
Yeah, it is a legal contract. So the way that this should be, and I think there's going to be a microscope as the insurance industry is starting to get in trouble. The agents now are being looked at, right? They're, quote, selling bad policies. Well, wait, these are the policies that are being offered. These are the policies that are being approved by OIR. So the agents are now under a bit of a microscope, and I'm certain that, I don't know, I'm certain that people have run across a situation where there was a misrep on an application and you have to give that heartbreaking news, right? And it's really the agent's fault, right? And they've enjoyed no liability or very little. I've tried an agent negligence case. It's very difficult. They take them all the way. They're terrible, right? So, but the client can. So when you do an application, you're sending out, in legal terms, you're sending out and kind of a request for offers. And then when they send you back your quote and you sign that quote, they've made an offer and you've accepted it. What happens if you sign the quote before you actually get a copy of the policy is that you've signed a contract and you've only seen one page of it. So you have the right, when you sign that quote or accept that quote, to see the entire policy. And they should ask for it. I'm shocked, I'm sure you guys are too, at how many people don't even have their deck page. So they should, and some of the carriers now won't even provide it to the end client. Yeah. I think I asked for some policy language before agreeing to bind quote before. Yes, Amy is correct. Yeah. Yeah. So you need to ask them for a full copy of your policy before you do it. And, you know, the other thing I want to say, and I will say this to the legislature too, educating yourself on what you're buying is only one component to it. The real problem is there is no policy that doesn't have a water limit in it anymore. So it's not just that you could have shopped around for a better policy. you literally can't get coverage for that item. And do we as a state want to say that that's okay? That people who suffer certain kinds of losses should be uncompensated? That's what we're saying.
Exactly. And education is such a big part. Those of you
Yeah.
who are members of our policyholder ambassador committee, we're rolling out a whole education campaign where we're going to be asking you to meet with your lawmakers and review their policies with them so that they know what they're not.
I love that.
It's going to be amazing, actually. We're actually going to give them a checklist, and they're going to go water loss, this, that. This is how much
Jeez.
you will have to pay if you have to claim, just so you know what's going on out there.
Nancy, you are so stellar. I just want to give Nancy a hand. I'm serious.
Thank you.
I've worked with a lot of people in my day, and you guys have an unsung hero here in Nancy. First of all, even think about doing that, and then to take the energy. We all have good ideas sometimes, and then we're like, God, I'm so busy in my life, I can't even chase that down. So for you to go and think of that and then implement it, I'm just so impressed. Gosh.
Well, thank you. I appreciate that. That's very kind. And this is what I do, right?
I know, but you don't understand. You have no context. You do it better than 99% of the people out there doing stuff. Truthfully, I'm
Well, I
serious.
appreciate it. Well, we can only do it with everyone's cooperation. So when we start launching that, I need you guys to join our ambassadors committee. You're going to get a really cool little lapel thing that says,
Yeah.
I'm a policyholder ambassador and all that other kind of good stuff. So definitely get involved, because this is going to be a campaign that might actually change some minds.
Great.
Okay. And Amy,
I'm in if I can help.
Absolutely. Absolutely. We're going to ask our
in.
sponsors and our associate members. And by the way, thank you, Amy, for sponsoring FAPIA. She's a valued sponsor, guys. Call her if you need any help. And I just couldn't be happier that you were able to do this with us today. Thank you.
I'm so glad. You know, can I just say the genesis of this was Nancy and I were on the phone one day. I don't even remember, working through Windstorm or some certain thing. And I'm reading a brief that someone wrote. She's reading a letter. And I was like, I wish people knew how to write. I'm like, I feel like they just, stick it in the middle. I said, I'll tell my associates, don't bury the lead. And she's like, I love the name of that. Let's do it. So
Funny. It's true. I mean, a lot of people don't get how essential that focus and clarity in communications are. So I'm super happy that you were able to bring this to everyone today.
Great.
And thanks to everyone who is still on the line. We still have 50 people on the line. Thank you all for hanging out for the Q&A.
Yeah. And I'll be happy to do another webinar on another piece anytime. So
awesome. Thank you. And we'll see you at FAPIA Live, right?
Great. Yep. Absolutely.
Awesome. All right, guys.
All right.
Thanks very
Take
much.
care. Bye.